We'll start the webinar with ma'am's and Dr. Rajendra's permission. Sir, if you could on your video, please.
Yes, please.
Yeah. Good afternoon. From Team Center for Violence Against Women and Mental Health, I am Dr. Krishma Viola D'Souza, moderator for today's session. We are a group working at Center of Excellence at NIMHANS, dedicated to establishing a comprehensive ecosystem in Karnataka that brings together expertise, lived experiences, media, training, and research, which ensures mental health support for women facing violence at various touchpoints. This initiative is funded by Department of Women and Child Development, Government of Karnataka. As part of this work, we organize webinars. Today's webinar is Protection of Children from Sexual Offense, Mental Health and Legal Aspect. And it's my honor to introduce Ms. Khushi Kushalappa, a dedicated counselor with over 16 years of experience in counseling adults and children. Since 2010, she has been a vital part of Enfold Proactive Health Trust in Bengaluru, focusing on supporting children affected by sexual violence and their families. Her remarkable work extends through various stages of the criminal justice and child protection process. Her collaborative efforts with police, medical officers, mental health professionals, and legal authorities have significantly contributed to the well-being and normalization of many children's lives. Her role in developing training programs for support persons across multiple states and her involvement in the compilation of the Handbook for Support Persons, released in 2022, highlight her commitment to child welfare and her expertise in this field. We welcome you, ma'am.
Thank you so much.
Today, we have also the privilege of hearing from Dr. Rajendra KM, an accomplished associate professor at NIMHANS, Bengaluru, specializing in child and adolescent psychiatry. Dr. Rajendra's esteemed career is built upon Sir's esteemed career is built upon a solid foundation of academic excellence with an MD and a DM in psychiatry from NIMHANS. Sir is recognized for his innovative research in enhancing mental health services and school-based mental health programs, and his commitment to this field is further exemplified by his numerous publications in renowned psychiatric journals. His work not only advances the understanding of mental health in young population, but also contributes significantly to the broader discourse in psychiatric research. Dr. Rajendra's expertise and insights are a valuable addition to our professional knowledge and practice in the field of mental health. We welcome you, sir. With this introduction, we will go into today's webinar topic again, protection of children from sexual offense, mental health and legal aspects. We will first hear from Ms. Khushi Kushalappa. Ma'am, over to you.
Thank you so much. I'll go straight into the session. I'm going to take it's 2:35 now. I'll finish by, let's say, about 2:55 or 3 o'clock, and then we can go into the next Dr. Rajendra session. So I will take you through some of the legal or the provisions of the law, a brief description of the law. I won't.
Ma'am, could you please be little louder, ma'am?
Am I audible now? Is this better?
Yes, ma'am. Yes.
Okay, thanks. Yeah, so I'll go into a few of the provisions of the law very briefly, because I understand that Pocso has been enforced for the last 11 years. While we might not see as much changes on the ground, we have been able to see that there are efforts being made, at least by individual officers, by individual medical professionals, by therapists, mental health professionals, by judges, prosecutors. So there has been a shift in the way in which sexual offenses against children are being dealt with in the system. But having said that, I will also say that a child and family are not able to see the improvement, so to speak, in the system. For them, even now, things are really as challenging as someone who walked into a police station 11 years ago was. So I'll just start with a case, Vignit. You can hang on to these questions. Some of you might understand how these situations are to be dealt with, but this is just there, so I thought we can just set the context. So this is unfortunately, a fairly common situation that we are faced with, where a 13-year-old, in this case, it's a boy. We don't have many boys who come forward. Typically, it's a lot more girls. So in this situation, there was a 13-year-old boy who shared with a school counselor that his family is going to the village for festival. He requests the counselor to help him find excuses so as to not to visit the village along with his family. On probing further, the boy shared that his older cousin sexually assaults him. The boy breaks down and begs the counselor not to tell anybody in the school or inform the parents. As the offender is a very close relative, the boy is concerned that his speaking about this would break up the family. This is a real situation. So, what can the counselor in the school, or a counselor who, if a parent were to bring a child to any of the mental health professionals here, if what would this counselor, what can they do, and what are their legal obligations? This is just food for thought for later. So, yeah, we'll go into very briefly what the POCSO Act um, has in terms of provisions. If you give me 1 second, I do want to set it. Yeah. Yeah. So, although we did have several laws in India to address sexual violence against children, starting from the Indian Penal Code, which has been around since 1860, there are a few crimes which are described in the Indian Penal Code, which address sexual violence against women and girls. And there's one section 377 which addresses sexual violence against boy, and that's what is known as unnatural offense or sodomy. So there is the Indian Penal Code, and then we've had the ITPA, the Immoral Traffic Prevention Act, which has also described a few sexual offenses. And then since 1989, we've also had Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act, which also described a few sexual offenses against women and girls. Then we've had the Information Technology Act, which is very relevant in today's day and age, where across the country there are more and more offenses which are being booked under the IT Act, and some of them are sexual offenses. And then, of course, we have the POCSO Act. Then we have the Rights of Persons with Disabilities Act 2016. And then we have the Juvenile Justice Act, or the JJ Act as it's popularly known as. We have the Child Marriage Prohibition Act, and then we have the Child Labor Act. So there was quite a broad framework to address sexual violence or sexual crimes against people. So then, what was the need to have a POCSO Act? So, what POCSO has done, I think, following a study in 2007, which said that over 53% of the children that participated in that study shared that they had faced some form of sexual violence or the other. So that was quite a startling and alarming revelation, because 50% of the children, it cannot be extrapolated, but the study itself was quite alarming, because there were 12,000 children who participated, and of them, 53% said that they had faced sexual violence of varying degrees, from very heinous sexual crimes to sexual harassment and things like that. So that set the context, and that set the ball rolling, um, because of which probably in 2012 we had the Protection of Children from Sexual Offences Act. So what, or is otherwise known as POCSO Act. So what POCSO Act did was describe sexual offences against children in much greater detail than they were in the existing laws. So in the existing laws, we had sexual harassment, and we had penetrative sexual assault, and we had sodomy. POCSO went a lot further into describing sexual offences. Also, what POCSO did was brought in mandatory reporting. So, Section 19 of the POCSO Act requires that any person who has information or apprehension that a child is being sexually abused, or has an apprehension that a child may be facing sexual violence, is required to report it, and the reporting has to happen to the jurisdictional local police station. And the if a person does not report such information to the police, they can face criminal proceedings under Section 21 of the POCSO Act, which has a jail term of 6 months to 1 year. And this reporting obligation, nobody in the country is exempt from it. You can't call yourself a mental health professional. You can't say that I'm a parent of the child. You can't say that I'm a close confidant of the child. I am the lawyer of the child. Nobody is exempted from reporting under POCSO Act. There is emergency medical care. There is care and protection, which is the responsibility of the CWC and the DCPU. There are child-friendly provisions which are described at all stages of the investigation, trial, and rehabilitation. There is something called presumption of guilt, which, unlike most, almost 90% of the laws that exist in the country or anywhere, the offender is presumed guilty until they prove themselves to be innocent. So, this is the provision of presumption of guilt, which is probably Section 27 or 29 of the POCSO Act. It is it is upon the prosecution or the state to establish that the crime occurred. Beyond that, it is the responsibility of the offender or the defense lawyer to prove themselves to be innocent. Um, when POCSO was enacted, every district in the country was made to designate a sessions court to where trials of POCSO cases would be handled, and they are considered to be special courts because the judges, the prosecutors, and the other staff are trained in manners of child-friendly courtrooms. POCSO provides for compensation in the form of financial relief immediately after the filing of an FIR. The CWC or the DCPU can order financial relief for welfare needs, for transportation, for all kinds of costs that need to be covered on an immediate basis. In Karnataka, the amount for this is 5,000 if it's a very grave assault in which the child had to be hospitalized, etc. They can start off with a initial amount of 10,000 going up to 1 lakh. Besides this, the POCSO rules provide for compensation under Rule 9. Rule 9.1 provides for interim compensation to be ordered by the special court, um, which needs to be paid within 15 days of the court ordering it. And the special court can also order final compensation at the time of disposal of the case. So, immaterial of whether the accused has been found guilty or innocent, the special court, based on the, let's say, the medical documents, the reports of a mental health professional that a child did face sexual violence, the special court can order final compensation as well. Other than this, children committing offenses below the age of 18 would also be considered as offenders under the POCSO Act, but they would be tried before the Juvenile Justice Board. If the person is below the age of 18, they would be tried before the Juvenile Justice Board. There is a exception to that between the ages of 16 and 18. If it is a heinous offense, this child can be tried as an adult after a preliminary assessment. All right. So very quickly to go into the offenses which POCSO describes, Section 3 and 4 describe penetrative sexual assault and the punishment for penetrative sexual assault. And Section 5 and 6 describe aggravated penetrative sexual assault and the punishment for aggravated penetrative sexual assault. So in what is penetrative sexual assault under POCSO Act? Penetration by penis, mouth, object, or any sort of body part into the vagina, mouth, anus, urethra, or making a boy's penis to be penetrated into another person's orifice. All of this would be considered as penetration. Previous to POCSO and before the criminal law was amended in 2013, the understanding or the legal description of rape or penetrative sexual assault was vaginal rape only. Subsequent to the Criminal Law Amendment Act of 2013, the description of rape itself under the Indian Penal Code has extended to all of the objects that I spoke earlier about. One thing, of course, is that there has to be sexual intent under Pocso Act for it to be considered as a offense under Pocso Act. For example, a doctor, a simple example is that a doctor inserting a speculum for a therapeutic need or for investigation, medical investigation, will not be considered as a penetrative sexual assault. However, a father inserting his finger into the child's vagina or making the child suck on his penis would be considered as penetrative sexual assault. All right. So, what is aggravated penetrative sexual assault? Based on the category of the person committing the offense, the nature of the relationship, relatives, family members, people of any armed forces, police officials, any person responsible for care and protection of the child may not be directly responsible. For example, the ayah in a school, a bus driver, a conductor of a school bus, the non-teaching staff in a school, the attender in a hospital. So any person who's directly or indirectly responsible for care and protection of a child, staff of a childcare institution, staff of any observation home, any facility that provides care and protection for a child or services to a child, including NGOs, any person from this background, it would be considered as aggravated penetrative sexual assault. If the child is below 12 years of age, if it's a gang assault, if it is multiple times assault, if the child becomes pregnant or contracts HIV or any other sexually transmitted infections, this and several other categories have been described under Section 5. There's Section 5A right up to Section 5U, which describe the categories that make it an aggravated penetrative sexual assault. So that's with penetrative sexual assault. Moving on to sexual assault and aggravated sexual assault. Section 7 and 8 of POCSO describe sexual assault, and 9 and 10 of POCSO describe aggravated sexual assault and the punishment. So, what is sexual assault? When someone touches the body of a child and it does not go into the details of which part of the body is child. It says with touching, with intent, touching of a child's body. And in the last 5-7 years, we've had several orders of high courts to say that it's not only touching of the sexual or the genitals or any private parts of the child. It can be any form of touching which is inappropriate, unsafe, and has sexual intent would be considered a sexual assault. Aggravating factors would be the same that I described earlier for aggravated penetrative sexual assault, except for the part about um, becoming pregnant or contracting a sexually transmitted infection. The key thing about sexual assault is sexual intent. So anyone who is committing sexual assault, the police or the investigating agency is required to establish that there was sexual intent. So, for example, a grandfather touching his granddaughter can be done in a safe and appropriate manner, and can also be done in an unsafe and inappropriate manner. We had a grandparent who, for about 5-6 years of the child's life, had been helping the child to change their clothes and um, had been also sexualizing the child, had been making the child sit on his lap when she was without clothes, etc. This child was a non-verbal child and didn't have too much of vocabulary with which she could explain to her mother about what she was going through. But her own sexualized behavior and the manner in which she was treating her siblings, her neighbors, and her cousins alarmed the parent a little bit, so much so that they took the child to a mental health professional who was, through play therapy, through the use of diagrams, was able to elicit from the child that they were being sexually abused by the grandfather. So there was no question in the mind of the people who were hearing the child that there was anything other than sexual intent. It was clearly sexual abuse by the grandfather of the child. All right. Then in touch-based offenses, using of a child for pornographic purposes, where there is touch involved, would also be considered as a sexual offense, and I think that is section 13 and 14 of the POCSO Act. Non-touch based offenses would be sexual harassment, which is section 11, and punishment is 12, where there is either stalking or exposing, disrobing the child, or disrobing themselves before a child, stalking through social media, through digital platforms, physical stalking, showing the child pornography. All of these would be considered as, or blackmailing the child, threatening the child after a sexual offense. All of this would be considered as non-touch based offenses under sexual harassment. Using of a child for pornographic purpose where there is no touch. So taking inappropriate images or videos of the child would also be considered as a non-touch based offense. That would be section 14 or 15 of the POCSO Act. Other offenses under POCSO would be failure to report a case on the part of any one of us. Having said that, I just want to quickly point out that POCSO under section 19 does not describe the time frame within which one needs to report. It does not say within 24 hours of getting to know you have to report. It does not say that within 1 year you have to report. It says that one needs to report to the police. So there have been situations when mental health professionals or people working in NGOs like myself have had to take some certain amount of time to prepare the child or their family to report the case to the police. And we have not been pulled up by the authorities, nor has there been any criminal proceedings initiated against us. But it would be useful to alert the authorities that you have some information about a child being sexually abused, and that you would need to, that you will come back to the authorities with the person who's ready to register the complaint. So that has in one odd situation, not one odd, in a few odd situations, in our experience in the last 12 years, we've gone and intimated the police, but the case has been registered a short while after. The police failing to record a complaint would be considered as offense under POCSO and under IPC. Criminal proceedings can be initiated, and that has happened in a few parts in India. False complaints, there is provision for false complaint. I cannot just go and allege that a person committed a sexual offense against a child, because the punishments are very high. False complaint also has equal amount of punishment when it is established that I made allegations against a person which were completely false. Yeah, so these are in terms of the offenses. The slides have the punishments which are provided for under POCSO Act. I will not go into the duration. Only suffice to say that for penetrative sexual assault and for aggravated penetrative sexual assault, minimum punishment is 10 years and maximum is the remainder of the person's life or even death penalty. So death penalty has also been brought in. So it's not easy to provide enough evidence to a court for a person to be punished for 10 years or 20 years or life imprisonment, which is why the conviction rates in sexual violence crimes are fairly low, not only in India, but in all parts of the world. But if we have time, we'll discuss that later. Very quickly, zero FIR. What is a zero FIR? If you come across a child who was sexually abused, assaulted in another jurisdiction and not in the place of where the child currently is, the police of the place where the child currently resides are required to register a complaint, a first information report, or an FIR. And after initial investigation and recording of the child's statement under Section 161 of CRPC, they would transfer the case to the jurisdiction of the crime, because investigation and trial will be conducted by the officials and the court of the place where the crime occurred. The other thing is, does a counselor, a mental health professional, or a social worker, or a doctor, or a psychiatrist who's attending to a child, who's treating a child or responding to a child, do they need to become a complainant in a POCSO case? The law provides that the police can themselves, if they receive information about a child being sexually abused, they can file what is known as a suo motu case. They can themselves take suo motu cognizance of a situation and register the first information report. This is also something that we have explored in the past. And here in Karnataka, and definitely here in Bangalore, we've had both of these situations, both the zero FIR and suo motu cases registered. So should doctors, CWCs, one-stop center staff, mental health professionals, counselors who receive information, should they be complainants? There is nothing barring you from becoming a complainant or providing information to the police, but it just is that you might need to give more time, appear in court more than one time, and provide statements before the police on more than one occasion. So if it is possible to circumvent that, it's just something that you can consider. What is it that the child and family needs after registering a case? It is very challenging to even convince a family to register a case. Sometimes, I mean, I say this because in the early years, even up to the year 2014 and 15, families were extremely reluctant, especially in cases of incest, to register cases. It was a unthought of thing to register a case against the grandfather, a father, an aunt, a grandmother, a teacher in the school. It was unthought of. So there have been occasions in the past, in the early years, where we've taken up to 1.5 months to prepare the child and family to come forward and register a case. Things are a lot better from that perspective as well. So once they register a case, and the reluctance that people have is because they have no information about the criminal justice system. They don't have any sense about time frames. What is going to happen after I register this case? What are my entitlements? So the law has provided that the police are required to hand over something called Form A, which is part of Pocso rules, which has all the entitlements of a child and a family once a case is registered. The other critical thing, which almost never happens across the country, is handing over of medical reports. If any one of us had somebody that we knew that needed to access um, therapeutic services, treatment, or went through a medical examination, a medical legal examination, it is our right to receive a copy of the medical report. It doesn't matter that this is a medico legal case. Receiving medical reports is a right of the patient or the person, the victim in this particular situation. Another thing that they need is speedy disposal of cases, or at least of the child's evidence to be recorded at a speedy manner, so that the child can move forward in life and they're not stuck, held back by having to remember everything that happened in the incident, the timing, the date, the day, the clothes they were, what to recognize that person. So if the child's evidence can be recorded at a speedy pace, that would also help. The law, in fact, provides that the child's evidence be recorded within 30 days of the court taking cognizance of the case, which happens almost 60 days after the case is registered. So there are several provisions in the law which are child friendly, which bear the competence and the capabilities of a child. But because of the backlog in cases, some of these child friendly provisions are not yet being implemented in a serious manner. Children who have special needs, it could be the need of an interpreter, a sign language expert, a special educator, a mental health professional, any one of these people um, may be required for the child, in order for the child to be able to provide their evidence in a clear and cogent manner. And this is a provision that the law has. The POCSO Act says that, the POCSO rule says that. There's a whole Rule 5 dedicated to details about interpreters, special educators, and translators. In fact, Section 39, model guidelines under Section 39 of the POCSO Act, have elaborated all of these roles really well. I would urge all of you to just read Rule 5 under POCSO Rules 2020. It will give you an idea of how you may be able to help. Support person is someone who continues to engage with the child from before the case was registered right until the case is disposed and the child has been rehabilitated and the child's has been life has been normalized. So a support person is the only individual through the entire trial process, not trial, from the reporting to disposal. This is the only constant individual that stays. The police have a very specific role to investigate. The doctors will provide therapeutic services or medical examination. The courts will come in when the trial begins. The CWC will address the care and protection needs. So there is really nobody who is with the child from beginning to end, who provides them updates and services and puts them in touch with the relevant authorities and experts, and that would be a support person. Yeah, so just I wanted to quickly go into a case. I do understand I'm running out of time. Anita is a 15-year-old girl who is diagnosed with mild mental retardation at the age of 3. Sorry, there's a typo here. She was sexually assaulted by a person in the village in 2014. Despite her disability, the girl can express herself, but it's a bit difficult to understand her speech. So, can Anita participate in the investigation and legal proceedings? If yes, how can it be facilitated? As a mental health professional, how can you extend support to the police and courts in this process? And where is information about such special educators and other experts available? These are just questions and discussions that we can have later. We've gone into the role of what each person does, but just to point out that in terms of child friendly procedures or child friendly provisions, what the law, the POCSO Act provides is for a child that the child, for a person that the child has trust and confidence in to be present from the beginning to end. So while the child is being spoken to for the first time by the police, while the child's medical examination and treatment and sample collection is happening, during the child's recording of the 164 statement, during the child's evidence in court, at every stage, the law provides for a trusted adult to be present. This trusted adult doesn't need to be a relative of the child, doesn't need to be the legal guardian. It can be any person that the child has trust and confidence in. So that's one of the key child-friendly provisions which are sort of violated quite constantly and repeatedly. But if we are aware that this is what the law provides for and requires us to do, then we can also confidently request that of the whichever stakeholder is violating this particular provision. The police are required to provide information to the Child Welfare Committee, both a first information report and Form B. The Form B is supposed to cover the preliminary assessment for which the police may need to go and visit the child's home, speak to the parents, see what are some of the things that they need. There is a format for Form B in POCSO Rules 2020. This preliminary assessment, which will also assess the risk that the child is under, may also speak to the mental health professional or the counselor to understand if there's any specific risk or safety concerns that need to be brought to the attention of the CWC. So this Form B and the FIR needs to be made available to the CWC within 24 hours of the case being registered. The CWC is responsible for providing shelter for children who are in need of care and protection. They could either be at loggerheads with the family. The family may not want to take their child back because of what happened. The family might be blaming the child for what happened. So, for more than one reason, the child may not be able to return to their home. So because of these reasons, the CWC is required to make arrangements for care and protection, shelter, placement of the child in an appropriate childcare institution. CWC is also required to ensure that all efforts are made to reintegrate with the family after a social investigation report is conducted and after any potential risks have been assessed and addressed. CWC helps with repatriation, immediate financial aid, and of course, normalization of the child's routine. CWC is the body that's responsible for also appointing the support person. So, while a support person will not at all be able to influence the justice process or the delivery of justice or finding the offender guilty, that's not at all in the control of a support person. But what they definitely do and influence is making the child's journey in the criminal justice system as easy as possible. One thing that I want to mention here, I won't go too much into this, but I would like to go into mental health professionals. As a mental health professional, some of you may be providing therapy to the child. So you're not, if the police ask you for a report on the child's treatment or what the child has been receiving in terms of therapy, you're not required to give a complete report a page by page, session by session report to the police. You can sum up what transpired and give it as a summary. Dr. Rajendra will go into this in more detail. Um, in terms of during the trial process itself, mental health professionals can ensure that the child is able to. I'll just tell you about this 2014 case. We had taken the assistance of psychiatrists from Department of Child and Adolescent Psychiatry at NIMHANS in 2014, and they had assisted with the recording of the child's statement before the police, recording of the child's statement before the magistrate, and we also had a doctor who came and assisted the child in giving her evidence in court. So that case did end in a conviction. I won't say it was only because of the mental health professional, but I'll say that they had a very key role to play in ensuring that the child's evidence was cogent and was a manner in which that the court was able to understand and appreciate what the child was saying. They played a very critical role, and subsequent to that, I mean, so many situations we've reached out to counselors, therapists, special educators, sign language experts to assist with children who have special needs. And really, their service has made the child's journey a little bit easier and a little more dignified, and also been able to impact the outcome of the case to a certain extent. Um, just last, I want to leave you with this slide, and I apologize for this particular session being as heavy as it was, but this is the reality of it. And I hope that none of the things that I said disturbed anybody on a certain level, but just wanted to share about this last situation where Anita is a 15-year-old girl diagnosed with mild mental, no, sorry, my bad, not this. Geeta is a single parent and a daily wage laborer. Her daughter Priya is 16 years of age with severe intellectual disabilities, accompanied by extreme restlessness, because of which she doesn't go to school, nor has the mother been able to find any daycare facility or residential facility. So typically, Priya would be left at home, locked, not even locked indoors, because she would step out of that little home that they had, come into the compound, but stay within the compound. So one day, Geeta returned home earlier than usual to find Mohan, who's a neighbor from the neighborhood, lying on top of Priya. Mohan and Priya didn't have any of their lower garments on, and it appears to be clear that Priya was sexually assaulted. So the question that I wanted us to ponder about is that, can Priya give a statement before the police? Should she be taken to the magistrate for her statement? Would her evidence in court be recorded? If yes, how? And is there a role for mental health professionals in this case? Yeah, I'll stop here and I'll hand it back to the organizers. Thank you so much.
Thank you so much, ma'am, for such an informative, enlightening session. Now we'll quickly move on to the next session. So, the PPT. Don't have.
Yeah.
He'll share it. He'll share it. Sir, will share it. Oh, see,
Only a minute, ma.
Yes, sir. So, yes, now we'll move on to the next session by Dr. Rajendra KM. Sir, we'll discuss about the mental health aspect of the topic. Over to you, sir.
Thank you. So I will quickly share the PowerPoint. Hope PPT is visible, right?
Yes, sir, it's visible.
Yeah. So I thank the madam for giving such an elaborate and more experience-based idea about POCSO Act and how it really plays down in the ground situation. So coming to the mental health aspects, so I will try to cover that within around 5 to 10 minutes of time. So basically, this experience of abuse is challenging, at the same time very distressing experience. Why is it? Because many times we have accidents, or we have some other criminal cases, but they do have distress, they do have trauma, but when it comes to sexuality and related abuse, it is more challenging. So why is it? So any trauma that happens, any change that happens, any experience which is sudden and unexpected, it will have its own impact on the growing mind. This is one reason why it is very challenging and distressing. Second, because of the context being very personal and being very private, and that boundary has been being violated, it leads to a lot of challenges in the individual at the emotional level. Even they are parallel challenges for the family to face, and at the social level. Because of this very personal, private nature of the crime that get involved, and because there is a social a narrative that gets built around such experiences, it is very challenging and distressing. Third, as it is very personal and private, and you need to uh, get over the trauma, you need to rejoin and integrate yourself in each step. It may be legal or social. That gives a sense of insecurity and anxiety in them regarding what can be expected, what can be the reaction, how one should react. So all this, even each stage by stage experience itself is can create distress. Lastly, in a small proportion of children, when they encounter such experiences, especially they are very intensive abuse experiences, especially from the trusted ones, it can alter their self-organization, like how they trust themselves, how they trust others, what do they value in them. So, and long-term consequences can be one of trauma and having traumatic disorder, post-traumatic disorder, or on the other end, having sexualized behavior, repeated high-risk behaviors, and what you can say, high-risk decision making. This sexualized behavior Madam had alluded to. So as you see, this is disclosure is a distress, then family getting through is a distress, then going through each stages of recovery and through the each stages of legal system is also a challenging process. So it is very complex in nature because of the aspects involved, which are not straightforward. They can be very straightforward to very, very complex in nature. So coming to the factors which can influence the coping of a child and the family for a experience is, one is the child's age, that definitely determines his her understanding and the ability, the emotional regulation ability, the confidence they have, the abilities to think through the situation and make decisions. So, if you want to summarize how skilled they are in making decisions in the challenging aspects. So, second is the factors related to abuse. So, what kind of abuse was it? Is it a non-penetrative abuse or penetrative? Was it of one time or multiple times? Who was the perpetrator? Was he unknown or known? So each of these factors will have impact on the level of distress and challenges, and also how those can be the person, the child who has underwent this abuse experience can cope. Whatever said and done, the child's ability and the abuse factors are even the social factors. The one most important factors which can influence the coping of the child in such situation is the family. If they have one trusted adult who can support them through the journey, nothing else can be so beneficial for them to cope in the situation. And especially when such persons have less capabilities, like in Indian context, where we have poor parents are illiterate, are from a poor socioeconomic background, they have less knowledge or education. As previously Madam was pointing out in her presentation, the support person is the only important person who stays with them through the journey. And that support can also definitely influence on coping, and that has a lot of impact in the overall recovery. So family's coping ability is the other part. What stress levels the family is in. Do they have any parents have substance use disorder? Those also impact how the child copes with the situation. And at the end, the social support, the Pocso has enhanced the legal support, and it also provides financial support as Madam described, and it has made the process time bound and child friendly. So they need not to face the perpetrator upfront, and there are many provisions they have made to reduce this re-traumatization. So legal system has gone through a lot of reformation, and even the officials and the judges have received training in these areas. So a supportive relative along with a support person can also make a major contributions for the family to cope in such situation. And definitely in such situations where the NGOs are driven by self motivation and a greater cause as their aim, their role also is so very huge, and they also can make things better for the child and the family. So the NGOs play role in giving shelter to the children, in rehabilitation, putting back the child to education, providing the safety environment. So they have a very huge role to play. Coming to how, as a person who is a mental health professional or a person who is providing counseling for such a victim and family, how should we do that? So any sudden event in our day-to-day life can trigger emotions, and such emotions are maybe related to that event, and it can be from anxiety to disgust to sadness to anger. Given the complexity of this experiences, you can we can't imagine the amount of distress that one may go through. So listening to those and validating those emotions makes a ground stage set, and also makes that victim and family what you can say trust or look upon for the further advice from such a person who wants to help them through counseling. Second part, once you have addressed their emotions, you have validated them, they feel a little lighter and they are connected. Your information, your role is to give these parents what it means for a child, how she or he will think about that process. There is no even a iota of guilt that child should be allowed to perceive from your end, because of the biases related to gender and social stereotypes, these children get re-victimized or traumatized even from the close ones. So it becomes very important to advocate and give perspective of the child's voice, and we need to give detailed information as we listened from the understanding point of the family who have sought support about their rights, and how system and legal system has been made child centric in each step, and how they can avail those supports in each step. And all this information is given to the family and the victim, so that in every step they can make a better decision considering their well-being and their situation. So next thing is that you as a counselor need to have connections with child welfare committee members, the child protection officers of the district, and other agencies like NGOs, and this will help them to connect to and also give the information what all support they can avail, so that they feel more empowered and supported in their journey in the larger run outside the context of counseling in their day-to-day life. Lastly, when it comes to the family to bounce back, like they face this situation, it will take a few weeks to months for them to recover and then restart everything fresh. While they do want to do that, the support needed at the school, support needed at the employment of their parents, those advocacy or those support needs, and putting a word what they are going through, and getting them that support was needed from their place also can go a long way in the recovery process. So this slide is quite a repetition of the previous slide, what I have, what you can say, gone through. One thing which I want to highlight is we should be very, very, what you can say, mindful or careful when we see children with abuse. These situations do arise, but very less likely. But if the abuse has happened, especially penetrative abuse, before 4 days, it is a very important priority to ensure the medical safety of the child because they are at risk for sexually transmitted diseases. At the same time, even for the evidence collection. So even when they want to get evaluated, they want to get examined, they want to get evidence collection done, they want to get treated, or they want to report. All these, when a doctor or a medical officer does, for each is expected to take a consent. And if one person is getting their evidence collected, doesn't mean that they need to file a case. So those rights do remain with the victim and the family. This information can be very, very crucial to enhance the convictions rate or to fight for justice. But at that moment, giving this information, empowering them is very important. This is as per the guidelines from the Ministry of Health and Family from the central government. Next is psychological safety. If the abuser is inside the family or near the vicinity, we need to report to CWC, and the police is expected to act on and then place the child in a safe place or in the NGO or under government girls' home to ensure that. So that is first part. Rest all, as I described in the previous slide. When it comes to referral to a specialist, when they have faced trauma, there can be 3 stages in which you can identify them. One, initially there is a sudden, what you can say, a state of distress, but it is expected to mellow down and get better over a period of a week or two. Usually there may be challenges in the sleep, in the food eating pattern, and the mood state. But if the parents are very supportive, the child can overcome such situation. Sometimes even parents can also get traumatized and get affected and their mental health, which needs help. So in the acute stage, if the symptoms are very severe, there is no sleep, there are significant emotional dysregulation, it is better to refer to a specialist for the services. Second is if the recovery is not happening as expected in 2 weeks and it is getting prolonged and the child is not able to feel better, your biological functions are not improving, that is at the second stage where you can refer. So at the initial stage, if the emotional dysregulation is very severe, at the second stage, if the emotional symptoms are not getting better gradually and the symptoms are persisting, their biological functions are affected. And the third situation is that the period the child has recovered after 1 month, 2 month, child was well, but later when you see at around third or fourth month duration, you can see the child has become very less interactive. He has become very dull. These situations can arise, what we call it as traumatic disorder, post-traumatic stress disorder. Such memories can start recurring in their mind and affecting their emotional state and the physiological arousal or the body states of anxiety. And in such situation also, the referral evaluation need for medication and counseling can greatly contribute for their recovery. So each step, the family needs guidelines from an initial stage to contain emotions, to make immediate decisions, then to understand the situation, to prepare them to bounce back to their routine and the child, Third, while they are going back to their routine, the challenges they face, they share that and then they get advice. So in each stage, we need to provide the support. So how to do those steps, what we discussed is that we need to listen to their distress first completely. We should not stop them in between. We should validate their distress and how challenging and distressing that experience is. As a counselor, our major role is to identify their strengths, the child strengths, the person, the primary caregiver, either a father or mother who has better ability to make decisions, support the child, recognize which support person can assist this family, because the person, as a counselor, we are new to them, and the trust factor will definitely take time to help them in process of decision. If an informed caregiver, informed relative gets on board, they start discussing that, the speed in which they can make decisions in those crucial times can be very, very useful and crucial. And lastly, as we discussed, giving complete education about the rights in each and every legal steps. Check what we have told, have they understood? If they are not, please don't hesitate to re-explain, because they are in a heightened emotional state. Even though they have, you see that it has toned down, it can just recur in their mind while even when you want to move to the next topic. So as they are doing and going through this such process, recognizing that changes, that they are looking calm, they are able to think through, they did good while taking a support from a known relative. So all these small changes you recognize and you appreciate, that will motivate them to take further next positive steps for better coping of the victim and make better decisions, which will be helpful in the recovery. Thank you.
Thank you so much, sir. Good afternoon. Okay. So we'll move on to the question and answering sessions. So there is a question here. Yeah. So the first question is anonymous attendee is asking, both the children are younger. One is 9 years and other is younger than 9. And the younger one is, the elder one is asking the younger one to kiss the private parts. Would that be under Pocso? First question. Unclear if Juvenile Justice Act also requires reporting. Ma'am, Kushi would like to take this question, ma'am.
Juvenile Justice Act does not have mandatory reporting in it. It definitely says that if anybody knows that that a child is in a difficult circumstance, that we need to inform either 1098 or in today's date 112 or the CWC. If we know any one of these resources, we would inform them. Now, the earlier question, which is such a difficult question to answer, is a 9-year-old asking a younger child to kiss their private parts. I mean, I think everyone in this room will know what a common occurrence this is. This is something that happens between siblings, cousins, friends. So in the law itself, below 7 years of age, criminal proceedings cannot be initiated. But between 7 and 12, there are certain exemptions that can be made, but a case will be registered and the police will investigate the case. But I mean, honestly, if someone were to ask me, I would say just speak to the child and explain to them what is safe and unsafe touch, boundary. Yeah, Dr. Rajendra, you continue, please.
Yes, sir,
Yeah.
please.
No, to add on to what Madam has said, we can look it from two perspectives. One is from a perspective of development, and one is from a perspective of legal responsibilities and is it a right or wrong thing. So, as there are 3 stages of development, below 6, for a child, a nose and their private parts are not different. So when we touch our nose, no one will say to stop. But when a child below 6 years touches their private parts, everyone will tell they should not be done. Basically, we are giving a message that this is a private part and it should be not touched upon and it should be covered. So this is the concept below 6 years will have. Below 10 years will have, it is a private part. They don't know what is it, what is the use, why we use that part for, except it is a private part, and it is related to our day-to-day excretory function. So, as such situations are quite common and they are called as experimentations. So, next, coming to the legal perspective, it is a very, very debatable question, especially when it happens between opposite genders and there is a short or a larger age gap. So, but if the context in which it was asked, it looks like an experimentation, and it's good for us to have a good knowledge of sexual development, know how a concept of privacy, how a concept of being personal evolves, and how this get evolved further in the adolescence. In the adolescence, it also throws the light how sex education is important in this current realm of situation. And many times we have seen this children who have experimented as peers after listening to Pocso classes coming in a guilt that we have done something, a great sin in the life, and we should be not happy, we should be held responsible. So such is the confusion that the lack of developmental perspective can bring in to the child also and to any person who is interacting with them. So especially about 12 such situation arise that becomes more challenging, and it needs to be discussed, understood, and the concept of experimentation versus abuse. Abuse will have a component of manipulation, coercion, then repetitive traumatizing. But some situations, what you can say is you need to understand the sensitivity and gravity, and then make one dialogue with one professional, and then take each case from a different perspective. So for this context, especially if they are about well, giving a white and black answer is very, very wrong to do. It's
Okay.
very gray in approach, but one can be mindful of these two concepts, apply that, reach out to one more person, make better choices. At the end, both are children, they need safety. In the previous session, madam also mentioned that even though when you know that both people who experimented, one may be victimized, he can be protected by major legal procedures. Those also one should be aware of.
Thank you, sir. Next, we will combine the second and third question, ma'am, because I think these are the common questions which everybody has in their mind, whether you are a professional or a layman perspective. So usually they think that if the victim is unable to speak for themselves or go and report, then what is the role of the people? That is usually one thing. And second thing, if it is not reported immediately, as Kushi ma'am has already said, what does the Pocso Act say about reporting? But still, there are confusions as to after months or years when somebody is coming out and telling this has happened to so and so person. So in that, also. And especially when the medical examination is not done. So these are the things that I would want ma'am, Kushi ma'am, to throw light upon as to reporting per se. Who has to report, how, when,
Sure.
the pathways of reporting. Yes, ma'am.
Both of us can take the question. One, the first thing is that any offense that happened after 2012, from the date that Pocso was enacted, there is no statute of limitations. It can be registered at any point. That's the legal, that's what it is from a legal standpoint. The
Yes.
next thing would be, what is the evidence that we will have if a case is registered after a month? If a case is registered 4 days after or 5 days after, also you're not going to have any medical evidence. And usually, not only in Indian society, anywhere, reporting of sexual offenses is usually extremely delayed. It takes a lot when the person starts feeling threatened, when they come across this person on a day-to-day basis, when the trauma of what has happened starts sinking into them, then they may say, okay, I'm not able to deal with this. I have to report this because otherwise me and other people are at risk. So more often than not, reporting is really very delayed. But Pocso provides for the case to be registered any time after Pocso was enacted. the role of a mental health professional in this would be really critical. I'm going to let Dr. Rajendra answer that, what
Yes.
all they can do. But there was one other question also related to this. In the event of a person with a mental disability or someone who is not able to speak, what can we do?
Yeah.
So in that situation, like in the third case that I had given, the mother witnessed this offender lying on top of her daughter. There is no other reason why a neighborhood man should be lying on top of a 16-year-old daughter without their clothes. The police registered a case. Now, this was a child who cannot sit still for 30 seconds. She's extremely um, restless. She cannot speak at all. The mother understands one or two things of what she indicates. So in this child's case, no statement was recorded by the child. Of course, she went through a medical examination because incident had just happened. There is ways in which the FSL can check whether the DNA of the offender was on the child, on the body of the child, in the body of the child, in the evidence in the bed sheets around. The neighbor who saw this person coming and going, the CCTV footage. So in today's world, there's not only medical evidence that one needs to rely on, there's other ways in which a case can be made strong. I'll stop here. Dr. Rajendra, please.
Yes,
Yeah.
sir.
So, like when it comes to the like what you can say about reporting. So, as Madam also pointed out, that timeline definitely many do take time naturally itself. So, as a professional, definitely we are not here to push them in the timeline perspective, but to promote and help them so that they feel empowered what they are doing and do and go ahead with seeking the justice. But mental health professional roles, as I said, this is quite complex. Like each one is different from other. First point is if the safety of the child is affected, like a known person is abusing and the caregiver can't provide that safety, versus a person is an outsider, it was an one-on event, and both the parents are willing to ensure the safety. So this makes a huge difference. In the first scenario, we should go ahead and report to CWC and police. The person who is interacting or interviewing, they may not come back to you. They may be lost in the follow-up. You may be losing one patient and the way to support them. But the safety of the child is more important than the counseling you are doing. So in that context, the family will also get alerted, systems will get alerted, the child will get benefit of safety, even though you lose the patient. So that is the first part. Second part, if the safety is ensured, both the parents know this, but they seek for time, make the document, and then you can take time and ensure that the process can be told. And you try for a few weeks or months, they are not in a process, they can't report. As the law obligates, one approach you can take is that it is also as per the Ministry of Health and Family guidelines in 2004. So you can document that you are reporting in possibility of alleged abuse, but the child and the parents doesn't want you to disclose the details of the event. That is called as informed refusal for the reporting. That is the third step. So I described three scenarios in one situation, but your therapy is next, safety is first. So when safety is in a concern, go ahead and immediately call up DCPO, SJPO, write a format report, and you don't worry about how your therapeutic relations get disturbed, because we need to select two ethical dilemmas here. Should I lose the patient versus should I report? What will be the consequence?
Okay.
The outcome should be best interest of the child.
Okay. Thank you, sir. We'll move on to the next question. I think this already Dr. Rajendra sir has covered as to how to validate the victim and what should we say, and in the slides sir has already covered. And ma'am is typing the answer for the next question, so we'll move on to
Private and semi-private mental health.
yeah. So there's a question from the semi-private and private mental health institutions. If they come across a child with a sexual abuse, what is their role, sir?
The process
So,
of this.
see, that's what the process remains the same. either you are in private setup or in a government setup.
Yes.
So if you feel that the situation is very complex and it needs higher level of care, one professional can do that and refer them with a clear referral note that we are referring for this reason. Second, whatever said and done, as per the law, when they know this, they should follow what is the standard process. And in such cases, documentation is needed. So, as per Mental Health Care Act, basic medical records that should be maintained in the OPD are already out, and there are guidelines. If we can stick to that and ensure that we have maintained the documents, that is good enough. And as the methods which apply for any setup will be applying for the private setups also.
Yeah, I think already Kushi ma'am, thank you, sir. Kushi ma'am has answered, but still again they're asking if I'm approached by an adult who is abused as a minor, as Kushi ma'am has already said, after 2012. So all these cases holds good as a POCSO. So this perhaps we can skip, and Kushi ma'am discussed the last case study about mentally challenged. This already ma'am has said. I think morning we have discussed about 161 and 164 statement. People still have confusions about that. Ma'am, would you please reiterate about the statements?
So the 161 is state CRPC is a statement that's recorded by the police as soon as the case is registered. And this statement is recorded in a manner in which it will aid the investigation. The police will base their investigation based on what the child says. So the child says, when I was coming back from school, this person used to meet me daily, take me to their house, and they would assault me in their house. And then I would come back home. I would go to the shop, buy a cup of tea, and then so there is a detailed history that the child has given, which the police will record, and they will base their investigation based on this. This statement made before a police does not have evidentiary value. It cannot be used in court. However, subsequent to this 161 CRPC statement being recorded, after the medical examination, etc., are completed, the child's statement before a magistrate would be recorded under section 164 CRPC. During the recording of this 164 statement, a person, let us say it is a child with intellectual disabilities, like in the 2014 case, a mental health professional assisted the child. The statement was being recorded by the magistrate, but an expert assisted the magistrate in recording the statement. So that kind of assistance can be provided, but nobody other than a magistrate or a police officer will record a statement themselves. If it is a child with intellectual disabilities, the law, if I'm not mistaken, is the 2013 Criminal Law Amendment Act, also said that this, in the case of a child with disabilities, the 164 statement can be used as the examination in chief, which means that the prosecutor does not need to ask the child what happened, hey guy to a night to, etc. But the defense lawyer, the lawyer for the accused, definitely has a right to cross-examine, but the child does not need to be examined if a 164 statement has been recorded. I'll stop here.
Okay. Sir?
Yeah, to continue and take the questions which are in the board, even when the father is the abuser, safety is the priority. And if the you report and police comes and asks, and CWC also gets aware that once child has said that the father is abuser, a system that is ensuring safety will get activated. So you may lose the patients, but safety remains first. That is to answer one more question that was there.
Yes.
So second part is regarding recording, as ma'am suggests elaborated, there are steps. How we can assist is help them to organize such recordings, because going to a police station is not expected. The police should come, they should be in a civil uniform, and they should record it in a child friendly place. But ensuring this and they knowing and asking police is very important. Second is they taking time, working through the emotions, recording the child to take time to think, build the narrative, and ask answer questions where, when, who, what, and how. Those answered in a very good narrative, and the child gives this organized narrative, and that to be done in a very calm state. If you can give this inputs to the parents, they can make the child calm and then prepare the child for even the police to report. Before the police only, they can rehearse the whole, what you can say, narrative. That can make a very strong evidence to build on regarding the reporting. And there is one more question regarding how many times they will be called and how many times inquiry will be. So usually they will be called on limited times. Usually when the trial happens, there is two people. One is who is trying to, what you can say, record the evidence. One more person who will cross-examine the evidence. Two times usually any person who gives evidence will be called in the court.
Ma'am.
Reporting and filing complaint.
Yes, ma'am. Sir, morning we discussed about filing a complaint and a mental health professional going and filing the complaint directly or giving the reports to the system.
Yeah.
Again, same.
So, Madam has alluded to this even in the today's
Yes.
presentation. Pocso clearly mentions that it's our responsibility to report. So we are not mandated to, what you can say, file a case, and that obligation will not come on us. So CWC is meant for this.
Yes.
So when you send report, once you send to police, if the case is getting done or not, you need to see. If there is a delay, you send a report to CWC. CWC has also have what you can say, authority to advocate for child rights and then take it forward, and they will look through that process. So lastly, as Madam pointed out in her presentation, there is a provision for support person. The moment case get registered through CWC, NGOs, through an NGO, this family can get one person who can stay through their journey. I repeat this person's presence can make a huge difference for the family of the victim and family itself in the whole process of rehabilitation and justice.
Yes, sir. There is a case given by Miss Sunita MM. So she is receiving a child who is in 7th standard and she had faked her menarche. And when she was teaching her about touch, good touch and bad touch, she revealed that paternal uncle was touching her inappropriately. But the perpetrator denies it. The family member feels that the child is also telling lies. And family member comes to the consultation to know whether it is a true incident whether the child is telling a lie. So this is a complex situation where Sunita wants an answer from us.
No. See, your professional role should answer this. Your role is
Yes.
a professional, that you will believe your client. So your client is child. So is it happened or not is not your what you can say role to judge.
Yes.
It's your prerogative to believe in child and advocate and make the family to trust what child is selling. Even it is a false complaint, it is okay. But safety is getting ensured is very important. And if the child has done it false, court will forgive. But why we should do that job? Our job is to ensure safety and advocate that the child's voice should be trusted, and we should advocate this to the family. And many times what happens, I will tell you that we want to report, but the family doesn't want to report. If you know that the family is able to ensure the safety, that both parents can ensure the safety of the child and they don't want to disclose, you persuade them. When they don't want to even further persuade, there is a option where you can complete your obligation, because we all have that threat that, okay, there is a 6 months of punishment, what will happen? So how it will, what you can say, look upon, because many doctors in Kerala also went through this situation. So basically there is, as pointed out, there is a health and family welfare guidelines which is given in 2014, where you can tell that I have got a report of alleged abuse and father and mother are able to ensure the safety of the child, and they are not willing for me to disclose the details. Let the police come and then take care of it. But that is when the safety is ensured. If safety is not ensured, you go ahead and do the job, even if you lose the patient.
Absolutely right. Dr. Rajendra has described it really well. See, at the end of the day, you need to have a victim for a crime. Even if you go and give that report, and finally, if the police are able to finally somehow or the other track down who this person is and go and meet them, they'll say, Illa, Agilla, nothing happened. I don't know why this doctor said, yeah, my child had some behavior issues, so we went and actually, no, nothing happened to my dog. There is no, you can't forcibly put the child through a medical examination, right? So that case is going to die down right there. But like Dr. Rajendra repeatedly has said, our doing this one thing may ensure that the perpetrator is alerted and then stops offending with this child. They understand that there is a criminal proceeding that can be initiated. They are saved by a whisker this time. Next time they may not be so lucky. So we do our small little actions like this can have a huge impact on the safety of a child. So we do what we have to do, and then the rest is left up to the system. And also connect them up with people who can help them through this process of reporting, etc.
Thank you, ma'am. Ma'am, here again and again, the same concepts have been framed in a different manner. The question is same. I think answer is already given. But again, I think people have confusions on the same lines as to if the home is not safe and there is a service provider and there is a shelter for the child, but the child doesn't want to leave the home.
Child can't make a decision, send her to home, she will get adjusted. So
Okay.
we should not bother about all that.
Yes.
See, when safety is concerned, child safety is important than her wish. When safety is ensured, child's autonomy will come into picture. So that is the primary. So if we know the concept, there is safety and there is development. Development can happen in a safe place. If it is happening in an unsafe place, it is neither good nor needed. So even if the child is disliking, let her go to safe place. At least if we report the place where she will continue to stay further in whatever the context madam also explained, there will be scrutiny and there will be ensured enhanced safety. You losing patient, we should not worry.
Yeah.
And sometimes this best interest concept, I would really like to take my child's opinion in everything. Okay, that's how I am. But sometimes it might be a risky decision that the child is taking. So it is my responsibility as the responsible adult to explain to the child that, Baba, this might not be in your interest right now. We'll have to wait for this. So best interest has to be weighed with the best interest, not only of what the child wants, but what might actually be good for the children. There's a whole concept of best interest.
Yes.
And you can be very clear to the child also. I know what it can make you to feel like this, but this is my role, and in this context, I am doing so. So this may be a consequence, and even I anticipate how you may feel bad about whole process, but I am doing in a best interest. So if you tell even this process, it will make you feel little, what you can say, acceptable for what you are doing. Usually that ethical dilemma makes us troubled. So you directly tell this. So basically being firm and being what you can say clear and being child centric. Even though child is not willing to listen, she has at least heard that. Once she has heard that, maybe a few weeks or a month later, she can even go through that hearing and then make meaning out of it and come and thank you.
Yes.
And many times we get, especially in situations of incest, where we are having to remove the child from their home. Unfortunate, but that's the fact of the matter. We put them in touch with other children who've been through this journey. So they understand, yes, it is challenging. Yes, the first 1 month was very difficult. I'd never been away from my mother or whatever. But here, look at me now. I'm going to college. I'm doing this. So just hearing from other people also is quite an empowering process. One thing I want to clarify, if the person was a minor at the time of the incident, it doesn't matter if we are in 2050.
Okay.
At the time of the incident, the person was a minor. Case gets registered under Pocso. That's
Okay.
it.
Okay. Very clear. Thank you, ma'am. Ma'am, we'll wind up. There are so many questions, but still we will
I
wind
will
up for the
add
day
on.
with the last question.
Yeah. I will add on to
Yes,
what
sir.
we discussed is that, see, many time we can prevent many situations. like especially we are working in a setup where there is lack of privileges or there are challenges. And usually these mothers will have that sense of insecurity regarding their children. I think something may happen in my home because my husband of this nature, he uses alcohol. So we can be proactive in giving advices that you shift her to hostel, you put her into a shuttle home. So many parents do this in their anticipation, and they can ensure the safety of many girls in NGOs. And we do hear such stories in many NGOs. So such situation can even help us to prevent. And as a professional, if we can be what you can say nuance to understand what the mother is going through or trying to communicate to us, even this approach is also useful to prevent such situations.
Thank you, sir. Last question, sir, and Kushi ma'am. So we will wind up with this last question. So morning we discussed it. Now one person is again asking, in case of special children, whether it is intellectual disability or hearing disability or any kind of disability, and the child is minor and has been undergone sexual abuse and is pregnant, and the family is not supportive, family is negligent. So in that case, what is our role as a mental health profession? We come across such cases, and what are we supposed to do? And the pathway, navigate the case.
So a case would get registered even if we are unable to ascertain who the offender is. There is a minor who's pregnant. So clearly a sexual offense has occurred. Police will register a case and the name of the offender will be unknown. During the course of their investigation, through CCTV footage, through a neighbor who saw somebody coming and going, through the child then slowly somehow coming out of their trauma or being able to articulate in some way or the other that this was the person who committed the assault on me, then the person during the investigation can be named, traced out, arrested, etc. can happen. The child, when the girl is having either a termination or she's going to go ahead and have the baby, there is DNA that will be connected and preserved. So when an offender is apprehended or identified, there would be a DNA match done to see whether this is the person who committed the offense or not. So the criminal justice system has ways and means. And as unbelievable as it might seem, our criminal justice system does work. It might seem amazing with the volume of cases, etc., but the police will keep this case in pending. After 6 months, suddenly they'll pick it up, they'll figure it out, they'll crack the case. So things do happen, sometimes maybe not at the pace at which we like, but things do move in the system.
Yeah, to take look from the perspective that, see, the government is responsible for the care of the victim and even the child who is in the womb, if their parents or the child can't take care of this. So the moment you refer this to police and CWC definitely takes over and puts Pocso steps in place and follows what are the procedures that they need to follow regarding continuation or termination as per the existing law. And madam has alluded to in the previous session also. And the child who is born is a government responsibility. What I am trying to convey is the moment what crime has happened is one perspective, the growing womb and child is a new perspective. And that care is under the government, and CWC will take each and every step. And as a mental professional, our role is not much than helping them to make a choice and knowing them to know their rights, especially for their parents. If these are the two roles, rests on CWC and court, and there is a procedures, there are SOPs, there are processes in place which will ensure the safety of the child and the newborn as needed.
Thank you, sir. So we will almost.
Sir, I had just one doubt. You mentioned that a mental health professional, despite consent being not given by the patient, the victim, who do we address it to, sir? You said that you can mention
Police,
not the CW. SJPU. Oh, right.
Okay. Thank you, sir. So for the benefit of the participants, I have apologies, I couldn't put your CV on the display. So, so we are winding up today's session. Thank you so much, Ms. Kushi ma'am and Dr. Rajendra KM. So we'll wind up with the acknowledgements. So we take this opportunity to thank our speakers for their insightful talks and discussions. Thank you, ma'am. Thank you, sir. We thank our project lead, Dr. Prabha S. Chandra, for her support and encouragement. We thank our co-investigator, Dr. Rashmi Arasappa, for backing us up throughout. We thank Department of Women and Child Development for providing us financial support to take this initiative and take it forward. We thank Nimans Digital Academy for helping us host this webinar. We thank our participants for their enthusiasm in attending today's webinar. Hope to see you all again with a new webinar topic in the next month. Thank you, one and all. See you again.